Good, whatever time it is when you're watching this. Hope you're all well. If you're watching this, I hope you're well. Hope your pets are enjoying this. Hope they always enjoy this. Not legal advice, and it certainly is not. Like, subscribe, please like, please share. Again, please let your pets subscribe. It would be a shame if you didn't allow that. So I was thinking about doing a video on something, and then kind of as I was doing that video, something else kind of came came up, and that's why the title of the video. So before I begin, just a couple of things. I don't know why whenever I use duct tape, it quacks whenever I put it on. Alternatively, sadly, I just got fired from the bank. I lost my bank job. One of the customers asked me to check his balance, and I pushed him over. Anyway, so I was thinking about finger motion, GTII. Finger motion and GTI are two stocks naked shorted. And this is not financial advice. Also, many people think they're about to run, and they think that finger motion will run before GTII, but they're connected because there's common ownership, etc. So I know at one point in time there was consideration about Alpine losing their ability to do business, and people thought that might trigger a short sale. So I've been following that and the appeal. And just brief recap: there's an appeal pending about FINRA's right to basically kick out Alpine without a full hearing, and so there's an appeal pending. And what I was going to do this video on, and which I'll address also, was to prevail in that. So the appeal is about an injunction. To prevail in the injunction, besides there's a bunch of other qualifications which Alpine might qualify for, but to prevail in an injunction, you also have to have equity on your side. That means you basically have to act in good faith, and the court has to be willing to give you relief because you're a good guy. So, um, kind of the way they look at that in this particular case was two factors. One, that there was irreparable harm caused to Alpine. In other words, if they got kicked out, that would be it. So maybe, arguably, they might satisfy that burden for the sake of argument. But the second one is public interest. And in their own brief, they argue it's in the public interest for, this is what Alpine argues, it's in the public interest for Alpine to stay and exist. And I certainly disagree with that. And I can't imagine that FINRA wouldn't be able to adequately argue against that in light of the fact of public risk by Alpine's existence. In other words, after they got kicked out, or the process of getting kicked out in 2022, they committed thousands of violations, ripping off customers. FINRA found that that's why they wanted an expedited hearing to get rid of them, which brought about this appeal. So, because the public has been found to be at risk, I don't see how a court of appeal would find the equitable arguments to be in favor of Alpine. If they don't find that there's a public interest, then most likely they have to rule against Alpine. That doesn't mean Alpine is done at that point in time, but maybe for this particular proceeding, they are done. And again, I think FINRA can circumvent all this nonsense just by going to federal court and just getting the business taken over by a receiver. So that's where I started. And then I was looking up the appeal, and I looked as of today, and there was no brief filed yet by FINRA. And FINRA is going to paint Alpine the scumbags that they are. They're scumbags, and that they're not entitled to relief. I don't know exactly what they're going to say because I haven't seen it, but in essence, that's going to be part of what they said. So then I started looking. Started looking, and I know that checkered history that Alpine has, and Hurry, who basically owns Alpine. And I started looking, and I saw some action that was decided, I think, in 2021, that had started in 2018. It was an enforcement action brought by FINRA against Hurry, Alpine, and others. for selling unregistered securities and other nonsense like that. And FINRA had ruled against, and if you recall, going back in time, part of the problem with Alpine is from 1984 through like 2022, 40 different occasions where they were disciplined, 40 different times, individual times. So I think this may have been one of those 40. So FINRA found it against them. The appellate panel found it against them, and it went up to the SEC, including Gensler, and they overturned it just on this one particular issue. But in that particular decision, they gave a factual background of Hurry. And again, it was in a different context, so maybe today they wouldn't describe it. But they basically said that Hurry set up a Grand Cayman company called, I think it's Cayman Trading, to facilitate the trading from foreign exchanges, foreign individuals through Alpine, through the Cayman Islands. So I've been involved in many discussions, and we've talked about why the Kramers are delaying the inevitable, because they're eventually going to get knocked out of the box, clearly. And we've talked about that they're engaging in asset protection. And if you look at her, and the Kramers are connected to Hurry, obviously. So if you look at that, and if you look at that document, by the way, in which the court ordered the basically the reversal of one of the disciplines, it goes through a litany of different locations, different potential squirrely entities that might be, some might argue might be able to hide assets, might be laundering money. We don't know what's going on, but it certainly seems suspicious. Certainly, Hurry at least admits that he is engaged and used that Grand Cayman to lessen the tax bite. So when we talk about naked shorting, one of the things we talk about is that the shorters don't have to pay taxes. And so interesting that one of the reasons that Hurry and the Alpine gang did this was to evade taxes. They might say legally, but they at least say it was to minimize tax reference. And also it relates to the foreign portion of the necessity for setting up the Cayman Islands as basically a vessel for running the transactions concerns me, because we know that a lot of naked shorts run outside the United States. So I think if someone went through this particular decision, so if law enforcement wanted to find out where might somebody be hiding assets, or a private investigator, I would go to this very document that overturned the decision in 2021 and look at the various locations that were mentioned and the various names of the entities. And I think that's a good place to look, which led me to a different thing that I hadn't really thought about in great detail. So when I was looking at the history through that, they indicated that for Grand Cayman Trading Limited to act in that capacity, they had to be audited and get a certified audit. And I don't remember the name. It was KPMG, which is one of the largest auditors, was their auditor. So they signed off on legitimacy of Grand Cayman Securities, Alpine, Hurry, etc. Some may question that that is an appropriate conclusion, and that in fact maybe KPMG didn't do a sufficient investigation. So I'm wondering, and I'm going to leave it at here because that's where I kind of took me to. There must be a bunch of these audits that occurred for all these companies that are engaging in illicit practices, and some large auditor, and in this case, I don't know if KPMG did anything wrong, but it seemed like Hurry and those guys were engaged in some squirrely business practices. So maybe KPMG, maybe they should have known. And maybe if we go through the records of all these companies that are getting naked shorted, we'll find that the entities that are doing it may also have been audited. And maybe That's a source of liability we really haven't considered. Is the auditors of these raiders, of these short seller counterfeiting raiders, perhaps that's something we need to explore. And they will be insured. So they will be carrying insurance, they'll have assets, they'll be a target that will be a target that could be tapped. So, anyway, so I just wanted to kind of go through that scenario that I was originally looking at Alpine and their scumbags, and I didn't think they'd be able to satisfy the equity grounds. And I think that they should lose the appeal. Again, in this case, maybe the law should be changed, but they have bad facts because they're bad actors. And then that took me to the Grand Cayman Islands, where Hurry, Alpine seem to be conducting business, and a document that references that. And then that took me to the auditor, KPMG, and whether there are issues regarding the auditors of the shorting companies, and they're basically legitimizing those companies. In this case, if KPMG had not signed off, Grand Cayman Trading Limited could not act in the capacity they did. At least that's what it indicated. Anyway, hope that clarifies something. I don't know what that clarifies, but it was just something I wanted to bring to the attention. So I think Alpine's still dead man walking. I really don't know if it has any impact on the price action of Finger Motion or GTII, but we shall see. And JR and I will be talking about it tomorrow night, talking about some of this stuff tomorrow night. So that's great. See you tomorrow night. Take care. Have a great night, evening, morning, afternoon, whenever you see this. Be well. Take care.